Thank you.
Well, thank you very much to both of you for giving us that information about your work, your report, and thank you very much for all that you've done. And now, colleagues, we will use the usual 5 minutes, which includes both questions and answers. And so the shorter the question, the less the preamble, the more you'll get in 5 minutes. And I'll start. Well, some people do. Some people have got in 3 or 4 questions. Others are lucky to get one in 5 minutes. Anyway, we'll start with the deputy chairs. Senator Seidman, first of all.
Thank you, Chair. And thank you both very much for being with us today and for your presentation and the work you did on your study for the government. Perhaps I'd start with you, Minister McLellan. We've heard evidence from medical professionals, but in particular from experts in jurisdictions where recreational cannabis is already legal, that the THC content in cannabis products available for sale on the legal market continues to rise at an alarming rate. For example, Dr. Bo Kilmer told our committee earlier this week that in Washington state, the average THC content for dried cannabis is now over 20%, with some vapor products as high as 75%. I was concerned to read on page 24 of the task force report that currently, quote, there is insufficient evidence to identify a safe THC potency limit. Dr. Kilmer suggested to our committee that Canada could impose a potency cap on products until more is known about the health effects of high-potency THC products, similar to the approach taken by Uruguay. What are the dangers of proceeding with legalization without any set limit on THC for dried cannabis?
Thank you very much, Senator. And in fact, we did directly consider the whole question of whether we should put a cap on potency in light of what's happening. Certainly the plants being grown today are not your grandmother's or grandfather's plants. And we looked at a range of factors. There is a market for high-potency cannabis, certainly with medicinal patients. Higher potency, they use less of the product. So there is a market for higher potency. If that market is not filled by the legal market, I can assure you it will be filled by the illegal market, thereby undermining one of the main objectives of this public policy change. The other thing we believe is that with public education, and that's why if you look at the packaging of product, but more general, not only the packaging regs, but public education generally in terms of higher potency product and what that means in terms of use and how you should be using it, that we believe it is on balance better not to provide that cap, because all that means is the black market, the illegal market will fill that. But Doctor, you might.
I'm sorry, I don't mean to interrupt you, but I know I have 5 minutes. But
Yeah.
I just want to ask you about a recommendation you made, because you did advise your advice to ministers. You say the task force recommends that the federal government develop strategies to encourage consumption of less potent cannabis,
Yes.
including a price and tax scheme based on potency to discourage purchase of high potency products.
Right. Yes, we did, because especially we don't want young people starting to use higher potency products. So what we suggested, and in fact it was based on a conversation we had with Dr. Kilmer, that in fact in this country we could do something that in the U.S. they hadn't done, which is set your differential tax limits on the basis of potency. And therefore your younger consumer, who generally has fewer financial resources, will buy the lower potency product with the lower price point, the lower tax point, and the higher potency product will be used by those for medicinal purposes or those who choose to use but have greater financial means.
So do you think that the fact that the government hasn't taken up your recommendation results in a missed opportunity for harm reduction?
I wouldn't say it's a missed opportunity. I would say that it was in relation to the taxation, higher potency. That was a novel approach. Nobody else has tried it. who has legalized. We suggested to the government that might be one of the harm reduction strategies and one of the incentives for young people not to go to a higher potency product. But I would be the first to say it's actually complex to get right in terms of the actual structure of that tax.
Did the government give you a reason for not accepting that recommendation?
No, certainly not as far as I know, no.
Okay.
I think probably simplification of the tax code was why Minister Morneau
Okay. Thank
went
you.
with a more traditional excise tax.
Thank you.
Well, there it is, a good example of 4 questions, 4 answers in 5 minutes. Senatrice Petitclerc.
And beat that. Merci beaucoup
Thank you very much for being here.
about the plain packaging, because I know this is one of the recommendation in the report, and we have seen what should be plain packaging for cannabis, and I was surprised to see how it is called plain packaging, but it is quite different than what we are going to have for tobacco. So I'm curious. I want to hear you on that. Is that what you had in mind when you suggested and recommended plain packaging, or should it be closer than what we are doing for tobacco?
Mark, why don't you take that first?
Well, there are people far more expert than I think I am, and probably Ms. McLellan as well, in terms of developing and designing plain packaging. What we think we've seen, and in my consultation subsequently with people who are experts in marketing, recognize that this does appear to be a reasonable approach to informing people of the potential risks, of avoiding the use of potentially promotional gimmicks, colors and so on, and also making sure that people are aware that these products contain THC. Also the quantity of THC, and this gets back to the earlier question, that is something that people need to learn, is how much does 5 milligrams of THC represent in terms of a dose, in terms of frequency, and that's only going to be possible when we have a framework where we understand the range of products that are available and they can be clearly and adequately labeled.
Thank you. I did not read anything about. I'm curious and concerned about the 18 to 25 age group, because a lot of the health expert and professional have really emphasized how, the developing brain until 25, and I understand that the bill calls for 18 as a legal age of consuming, but to me there seems to be this vulnerability, this specific vulnerability for this group, and so I wonder if this is something that was discussed, or if this was and if it should be addressed either in regulation, in the maybe not advertising but awareness campaign, or if we should target and protect specifically that age group, and how it should be done.
We spent a great deal of time on age, right, Mark? That was one of the biggest issues with which we dealt. We had very thoughtful submissions from a wide range of people, as you can imagine, including the CMA, the Canadian Nurses Association, and others. They're all available on the public record. But at the end of the day, we had to balance some realities, if you like. What are those realities? One, the biggest age cohort of users in the country is 18 to 25. So if you jack that age up to 21 or 25, you're completely undermining the purpose of legalization and regulation in the first place, or one of the purposes, which is to try and keep that big age cohort of individuals out of the criminal justice system, out of the legal system generally. We know they're going to use. I mean, we can't be naive. They are users now with a criminal prohibition. They are going to continue to use, and therefore let's accept that reality. Let's have a safe supply that they can purchase that isn't cut with things like fentanyl. We've had at least one case of that in Ontario, I believe. Let us understand that, as I've said in my opening remarks, that in the society in which we live, 18 is the demarker of young adulthood. Now, we knew that provinces would wish to be symmetrical with their drinking age. So in my province, it's 18. In Quebec, it's 18. In other provinces, it's 19. But 18 is basically societal, social demarker for young adulthood, the age at which we trust people to vote, the age at which we trust people without their parental consent to join the military and die for their country. So we actually believed that with the right public information, that young adult at 18 could make the decision as to whether he or she should consume some amount of cannabis in whatever form.
Thank you.
Am I done?
Yeah, you're done.
Okay.
Sorry. Senator Munson.
I always know you as minister, Ann, so I'll have to keep with that. But a twofold question. There's a divide in the Senate, and there will be amendments. There's different points of view on this sort of thing. And we had the Aboriginal Committee recommend up to a year delay. We've had some senators who've felt that provinces should be responsible for the number of plants in each province. Those are two issues that I want to address. They talk about in the Aboriginal committee that no consultation with First Nations, yet I hear you say in your opening statement you consulted, your group consulted 30 Indigenous groups. When that kind of conversation was going on with these 30 Indigenous groups, which sounds like a good measure of the Indigenous peoples, what did you hear then? And I'm wondering why now, after what the Aboriginal Committee heard, they're looking for a 1-year delay. And also on the issue of 4 plants should be, I don't quite understand why that would be there, but just leave it to the provinces. This is Canada.
Let me just say a little bit about the Aboriginal consultations that we undertook. And Mark, you might like to comment on the 4 plants. In terms of our Indigenous consultations, we knew from the beginning that they would be an important voice to be heard. And that's why we had a roundtable specifically on Indigenous issues and viewpoints, and we invited a wide range of representatives from national organizations, from local communities, from the Aboriginal healthcare professions, and so on. And in fact, at all our roundtables we held across the country, we made very sure as a task force that Indigenous individuals were invited. Now, not everybody who was invited from the Indigenous community came to our roundtables or our Indigenous roundtable, but they were absolutely invited because we understood that was an important voice. We have heard, as probably the Aboriginal, I know the Aboriginal Committee has heard, a diversity of viewpoints. We heard some very articulate chiefs and submissions from provinces, Aboriginal groups in Saskatchewan, just as one example, where they have carefully thought out, and they actually presented to us a template for what Indigenous involvement in legalized cannabis could look like going forward. So there's a group of people who have thought this through and presented us with a template, and the government with a template for Aboriginal involvement in this area. Was that every chief? Was that every community? Absolutely not. We also heard from elders, and of course, elders, some of the elders from whom we heard expressed the concern around the drug issues that especially their young people face in their communities, the social and economic harm that exists now, right? And this is the thing I think we need to focus on, that in fact the elders talk to us passionately about the fact that these problems exist in their community now. So the issue is, does it make it worse, or do we have a chance with legalization, based on what you heard from Mark, around research, about new interventions, to actually make it better for these communities with the right supports? And the Government of Canada and most provinces have committed to use some substantial part of their revenues, their tax revenues, for exactly mental health programming, addictions programming, the federal government's programs for support on in First Nations and other Indigenous communities. we didn't hear from every Indigenous person in this country, and that is not dissimilar from any other group. But we as a task force were from the beginning very aware of both the economic opportunities. We heard from articulate young chiefs who see this as an opportunity for sustainable economic activity in their community if done right. We also heard from elders who were concerned about what this might mean for their young people. So I think we heard the diversity of opinion you heard, which was why we clearly recommended to the Government of Canada that consultations and collaboration need to be ongoing. But to Mark's point, this is a process. It's not a point in time. And those consultations and that level of collaboration can take place before, during, and after legalization. Mark, you might want to talk about the plans.
We're up to the time.
I'll try. I think there are various levels of readiness for this process in different levels of the country. And some communities have just now beginning to engage. Some have begun thinking about this a long time ago. However, it does not mean that we should delay the implementation of a legalization act, because it will not prevent problems from happening now. This is already going on in communities around the country, including Indigenous communities. By making it and delaying the process simply prohibits us from engaging, from dealing with the issue in a more open and transparent manner.
On to Senator Poirier.
Thank you, Chair. Thank you both for being here and for the presentation. My first question is for you, Minister, and you actually made a comment a few minutes ago about making sure that we have the right public info out there on the cannabis legislation. The task force, you recommended to the Minister to provide that Canadian with that information so that to make sure that they understood the regulatory system. But we heard I think it was last week, if I'm not mistaken, from the Canadian Bar Association and also from other witnesses, that right now what many Canadians are hearing is that the cannabis will be completely legal soon, and which is not the case, since the bill still maintains a strong criminal regime and many aspects of possession, distribution, and cultivation. When your report was done in 2016, the government clearly didn't take the time to properly inform the Canadians. So to ensure that the Canadians are well informed of all the consequences, whether it's health, whether it's law, whether it's otherwise, should the government, in your opinion, delay the legislation to make sure we have the proper information out there to the people?
No, and I think you've just heard from my colleague that for other reasons he doesn't think it should be delayed. Let me say that we did notice, actually, as we began our roundtable discussions across the country, that in fact the commitment of the Government of Canada and the mandate we were given was to engage people on legalization, regulation, and restriction of access. Unfortunately, there were a group of people, and to some extent the media, but not entirely, focused on legalization, and they forgot about the rest of the mandate. But our report is all about actually regulation and, quite honestly, restricting access, especially to young people who today have very easy access to product, and nobody knows the quality of that product. In fact, I agree that because, for whatever reasons, people chose to focus on only one word of the mandate, our report is embedded in the other two words, restriction and regulation. And public education will be key. Absolutely, and that's why we make that recommendation over and over again in the report. We talk about the importance of public education. That public education has begun. There is a working committee of the federal and provincial officials who are coordinating public education messaging. I think if we go on social media, you see more and more of the public education targeted at young people. We learned from the state of Washington, don't bother with a piece of paper for a young person. Don't go on television. That's not where they live. It is all social media. Washington had to tear up, after spending millions of dollars, their youth-focused education campaign because they did it wrong. And what did they do next? They went and talked to young people to figure out how you actually reach young people. And in today's world, it's through social media, which is why if you go on social media, you will see a lot of that education. Is it enough? Will it ever be enough? No, because public education is an ongoing process, and the government all governments
Can I
and
just-
civil
yeah.
society need to do more.
I don't want to lose all my time.
No,
I
I'm
just-
sorry.
It's just, no, it's just to follow up on that, exactly where you're at, and maybe Dr. Mark Ware, you can jump in if you feel you need to. But we know that despite the millions of dollars that the government did announce in the budget, Health Canada has only spent $295,000 on its official cannabis public education campaign. And actually, that campaign that was targeted especially to the youth only began in March of 2018. So the concern here is last year, they said that Canada should boost spending on intensive public education to make sure that with the research on the impact of the marijuana and to not wait until 2018. So I'm just wondering, what are the consequences of the legalization cannabis without the youth fully understanding the risks, because eventually, from what we're seeing here, not a lot of the money has come forward, and what has come forward has only started in March 2018.
But first of all, I don't agree that the youth are not understanding what's happening with cannabis. I think they're extremely engaged. They're tracking this, as Ms. McLellan says, through social media. This is a topic that's in the press almost every single day. It's in the news every single day. It's dominating Twitter and social media platforms. So I think the youth are engaged. They're well aware of what the risks have been. I think they've also been told for decades. In fact, when some of us were youth, we were told about the harms of cannabis and the dangers, and it continued to be used. It continued to be widely used illicitly. I think the youth are aware. I think we underestimate their intelligence and awareness of the issues, and if they're taught and if they're tuning in to messages, including the dialogues in these chambers, including what's being discussed in the public media, there's an opportunity for public education at every single intervention that we do. Every single talk or word that we put out there is going to be heard by young people. Teaching them that cannabis use is an adult activity, that the longer they delay using cannabis, the more safe it is for their developing brains. Teaching them that they should understand the potency and use low potency. These are simple messages. The lower risk cannabis use guidelines published by CAMH, endorsed by multiple medical associations, all speak to the reality of cannabis use by young people and encourage and teach ways to reduce those. Those documents are out there. They're being disseminated. They've been endorsed by the Canadian Medical Association. So I think there is information out there, but it's up to all of us, including parents, including teachers, and including all of us as professionals, to distribute this information at every opportunity we have.
Senator Lankin.
Thank you very much. Thank you both for being here today. I would like to start, Ms. McLellan, by thanking you for the three issues that you went through. They are three of the issues that we hear a lot about all the time, and I attended your earlier briefing made available for senators several months ago and heard about that, and I was impressed that these issues were explored in depth by the committee, and that for the most part the government actually heeded, and as a minister I would have done that too, because in an issue like this it gives you much more ability to not deflect, but to say that there are others involved in looking at this over a longer period of time. I want to ask you about one issue that you didn't talk about, and that's 12 to 18-year-olds. If I may, the Criminal Lawyers Association was here, and the Canadian Bar Association. They both raised issues, the equity issue from youth and how they're treated under the Youth Justice Act, and the treatment of adults here. And they propose that if a person under the age of 18 ends up going through the ticketing process, et cetera, but then there can be all sorts of conditions put on them, and if they violate any of those conditions, they could be brought back before the justice system and could end up facing sanctions that are much stiffer than if an adult was in the same situation. I'm probably not explaining that, but as a former justice, explaining it well, but as former justice minister, you will know what the issue is there. Can you help me with your interpretation of whether we have either constitutional equity charter issue or just a disproportionate effect on young people? Does it vary from other bills? That's what I'd like to explore.
Quite honestly, I think the reality is that there will not be a disproportionate effect on the 12 to 18-year-old. Going back to the task force report, what we make very plain in the report is that we do not believe the criminal law is the appropriate vehicle to deal with young people who are found with small amounts for personal possession or small amounts for personal use. And that's why and that's why you see in the legislation the 5-gram issue. And what then that spoke to was the fact that we don't want anyone under 18 using, right? That's clear, and the report is clear. But we do know that some in that age cohort will use. We don't think it's appropriate they're caught up in the criminal justice system. We left it open to the provinces and the territories to fill the gap, if you like. That was quite deliberate, right? It wasn't an accident. And they have all done so. To the best of my knowledge, they have all done so.
So you don't see that there is an equity issue? I'm sorry to
No,
cut you
no,
off,
I
but-
don't think so,
Okay.
because they will be dealt with in, look, practically in most cases, the policeman, the beat cop will take whatever the kid has and say, you know what, go home, this is a warning, right? That they might give the kid a ticket, and there's a fine. And yes, that involves a certain issue, but that is much, much better than having that young person tied up in the criminal justice system, either the Youth Criminal Justice Act, well, it would be the Youth Criminal Justice Act.
I think that we've heard a lot about not wanting to criminalize young
Yeah.
people, and I agree with that.
And-
I was just more interested in this technical legal.
And, you know, I think it's an issue that I would say, if it were ever, I honestly do not see that arising practically.
Okay. I want to move on to another issue again. This is about the technical writing of the law and the interaction between the federal government and the provincial government. And you just indicated that on this, it was purposefully written in a cooperative federalism approach to allow for the provinces to do that. On the issue of home grow, it's quite different. The provinces of Quebec and Manitoba have taken a different position and have said no plants. And the federal government has said, well, we won't take you to court, but if an individual citizen takes you to court, which you know that will happen, we will defend the federal record, i.e. this is a law of general application, it's a law of federal paramountcy. I don't understand the reason for that. I don't know why a patchwork approach to the number of plants is so harmful. I don't know why we can't leave that up to the provinces, who are also going to have to deal with the issue of multi-unit buildings and other sorts of things. Do you have a reason why it would be wrong for us to pursue clarifying that the provinces do have the ability, like in the treatment of 12 to 18-year-olds, in this treatment they do have the ability to set a limit lower than 4 plants, including 0 plants if they wish?
Well, I'm not going to get into a constitutional discussion here. That will be up to, I guess, the Attorneys General of Quebec and Canada. What I will say is that after hearing all the evidence, we believed that cannabis is going to be legal. The plant is going to be legal. And we allow people, for example, to make their own wine. They're allowed to grow tobacco, right? And if you are actually legalizing, does it make sense to have an absolute prohibition on the growing of what is now a legal plant, a plant that leads to a legal substance? We took on board the experiences of states that have legalized, and they all, but the state of Washington, have home grow or home cultivation with a certain number of plants. In fact, some of those states, except Oregon, have a higher number of home grow plants than we have. We thought, on the principle of caution and public health and safety, better out of the box to keep this restrained for plants. We actually don't think many people are going to grow their own plants. Very few people make their own wine.
Come to my part of the province. Honestly, I'm serious.
No, but
It's
that's because there is not readily available quality assured retail, right? And there used to be lots of stills right after prohibition of alcohol. We went back and looked.
Come to my part of the province, there still are.
Yeah, well, as the stores actually and the market regularized, very few people make their own wine or make their own booze anymore. And
Okay, my question really was, can't we let the provinces
well,
decide the number?
Sorry.
Yeah.
Senator Malte.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Minister, as my colleague mentioned, Quebec will be stuck in between a rock and a hard place. Bill C-157 is going to be tabled this week, and it will prohibit the growing of 4 plants. The federal legislation will say this is allowed. So in Quebec, as of the 1st of July, will we see the Sûreté du Québec policeman seizing 4 plants in an apartment, and then we'll see the RCMP come back returning the 4 plants? What will happen to citizens in Quebec?
I am not the Minister of Justice. I used to be, but I'm not anymore. And I'm not part of the Government of Canada. We were an independent body set up. We heard the evidence around whether people should be allowed to grow a certain number of plants in their homes, this now legal plant. And we took it all on board and we decided, yes, caution spoke to the fact that 4 plants were reasonable. Let's not be too paternalistic around this now legal plant. But if Quebec chooses zero home grow, and the federal government has allowed 4 plants, I think the federal Minister of Justice has said that she will not challenge that in court, but some member of civil society might, and then the matter will be joined and it will be resolved ultimately probably by the Supreme Court of Canada. That is all I can say because I am not a member of the Government of Canada.
Merci. Dr. Ware.
Thank you. Dr. Ware, what can be found in cannabis? Well, there are several chemicals, cannabinoids like THC, CBD, some other acids. In other forms, there are terpenes, ingredients that give to cannabis its smell, its characteristic odor, etc. Can lead or mercury be found in cannabis? Arsenic? Perhaps, if it is grown in an illegal fashion. Some other elements, pesticides, etc., might be detected. The tests that were done on this dealt with medical pot. And this is what was found in these plants that were examined. Are they very small quantities? It was a laboratory that is authorized by the government, the only one that's authorized to verify limits. It's called the Phytochimia Laboratory. There are chemists and university scientists who do the research there and work for the lab. Is this available? Has it been published? Yes, it's been published. It's in La Presse of today's edition. Was it published in a scientific journal? No, there's an article in La Presse, Le Goût et l'Odeur. There are a lot of things published in La Presse, but, you know, we have to look to scientific journals. Here it is. I'm showing it to you. I imagine that you were aware of the existence of this lab. Well, with the prairie plant system, a lot of people claimed that cannabis contained mercury, lead, etc. But it's your competitors. These are chemists, university researchers, people who have the same diplomas as you, and they don't receive grants from pot producers. This is a private lab sanctioned by the Quebec government that calls upon this lab to analyze medical marijuana. That's what you're doing now. If you're analyzing pot for everyday users, well, it's illegal if that's what you're doing right now. Because the bill hasn't yet been adopted. So if you're doing this analysis, well, it's illegal. And it says that in this report that there are 96 pesticides that were found within this pot. I'm not aware of it. Have you carried out this type of analysis? No, not personally. Thank you very much. Your time is up. And I'm not really apprised of all the details.
Senator, could I just clarify? Because I'm sorry, but if you were suggesting that Dr. Ware was doing something illegal currently, it is quite appropriate to analyze product and has been for a long time at laboratories for research and medicinal purposes to know whether there are pesticides or other chemicals, right? I mean, that's not, keep in mind, you have to distinguish between the recreational market, which will not be legal until whatever legislation is passed and proclaimed, and medicinal use and research, where in fact labs across this country are certifying product as pesticide-free or chemical-free or only with these authorized chemicals.
Okay, Senator Bernard.
Thank you, Chair. Thank you both for being here today. I'm going to try to ask two questions quickly. First, I want to pick up on a question Senator Lankin was asking about age and the age limit. And to be honest, it really scares me when I hear that police officers will have discretion and that some young people will be given a warning and sent home. And I think most people here know that for some young people that will not be the case. For racialized young people, for Indigenous young people, they will not likely be sent home with a warning. And so what recommendations would you have for how we address that? Because I don't think the current plan would work so well.
I think, well, certainly in our task force report, the point we made was that we did not want the under 18 user, if not trafficking for profit, in which case that person probably would be brought into the youth criminal justice system, but was found with a small amount for personal use, that we didn't want them tied up in the criminal justice system, in fact, for maybe some of the reasons you've identified. And that, in fact, but we don't want them using. The age is 18, and if you use under that age, that is against the new federal regime. It was clear from the outset that the federal government wanted the provinces to use what we could call administrative sanctions to deal with the under 18 user who happened to be found by law enforcement. And those provincial laws deal with a warning, ticketing, those kinds of things, and not a criminal charge, not a trial, not a record. Look, and we have talked a lot, and we heard a lot about racialized enforcement of the existing prohibitions, which is, again, one of the reasons that that legalization, hopefully, will start to make a more equitable situation in terms of law enforcement. I didn't say that very elegantly. I apologize. So all that to say that you have to have some system of sanction for the under 18. We're not legalizing use for that category of people. So there has to be some opportunity for sanction. But it may be a warning or it may be a ticket. But it won't be much more than that.
And so my interest would be in how do we guarantee that those that will be administered fairly and equitably?
I think it's with public education and training. I'm not naive. I think we are all aware of situations where there's, at least on the face of it, appears to be an unfairness or inequity in the application of the law. So I think we deal with this through better training of our law enforcement officials. We deal with this through more public education, and we also deal with it through helping families and those who have under 18-year-olds get the basic message that you shouldn't be using and your kids shouldn't be using. This is not a good thing, and it is not, it is against the law. But there's no magic answer here, Senator. I wish there was, that we could have an equitable, colorblind, ethnic blind, whatever criminal justice system, but we don't. But we are working every day to get there.
Good.
Okay.
Do I have time?
Oh, we got 1 minute.
I've heard from many African Canadians that they have not been consulted or that their voices are not there, not present. And we know the war on drugs in Canada, similar to the U.S., has led to over-incarceration, especially for single possession use. Mm-hmm. 4 cities in California have created equity programs to help people personally impacted in those communities to get an early stake in the legal cannabis business mm-hmm. in those cities. What would you say to something like that happening in Canada?
We did not deal with that directly, and as you know, our task force report did speak to that issue in relation to Indigenous Canadians, and we did make recommendations around ongoing consultation with the government and economic opportunities for Indigenous Canadians. I think that your suggestion is one that should be taken under consideration by the Government of Canada, because I think there are communities, and African Canadians, I think, are one of those communities. If you look at not only experiential evidence, but criminal stats that have been affected in disproportionate ways by the existing prohibitions. So what I would say to that is that it is something that I would encourage the government to look at very seriously.
Thank you.
Okay, thank you. I have Senatrice Meiji, Senator Ahmedvar, Senator Sakis, and Senator Patterson left on the list, and we've started a round 2 list if anybody wants to get onto that. Senatrice Meiji.
Merci, Monsieur le Président. Ma question.
Thank you, Mr. Chairman. My question is for Dr. Ware. In the research work that you've done, because one of the arguments in favor of home growing is that we've already allowed people who use marijuana for medical reasons to grow and purchase marijuana. So have you polled patients who already grow marijuana at home? Is their number sufficiently high for us to rely on what they may say? Because from what I know, there are people who are ill. Are they able to care for plants at home, or would they prefer to purchase at a reasonable price after the legalization? Beyond the possibility to buy from a recognized retailer, you can grow for your personal use, for the patient, or you can go through a designated producer. I don't know what the numbers are for both of those groups, but there are more than 10,000 individuals who are entitled to grow or to designate someone to cultivate for them in their stead. As Ms. McLellan said, the worst problem, the most serious problem, is with regard to the designated individuals, because you could designate one person who could designate another person, etc., and this could broaden, and there could be a risk of diversion. With regard to personal use, I don't know many patients who grow themselves and for themselves, but there are some patients for whom growing their own cannabis is also a therapeutic approach. It's therapeutic for them to grow their own medicine. It's important to them. For example, people taking chemo for cancer. But I don't have the exact numbers. But I do believe that the problem is more on the side of persons designated to grow for these individuals. A second quick question, if I may. When we heard the representative of the Canadian Medical Association, he was suggesting that instead of having 2 management systems for, on the one hand, medical and on the other hand, recreational marijuana, that there be a single track. What's your opinion? The CMA made a public argument around this, so it was no surprise to me. There are 11,000 doctors who have at least one patient under their care who's authorized to grow cannabis for therapeutic reasons. The CMA represents 90,000 medical practitioners, doctors, and there are 10% of doctors who truly did accept to play this role and to authorize this for patients in need. I think that the CMA must recognize that there are doctors who are ready to do this, to develop education materials as well. We can't put everyone in the recreational market. To do so would not recognize the rights of patients to have a discussion with their doctor with regard to choosing the dosage, discussing the results of the therapy, etc. And for me, it's an opportunity for the doctor to be involved with a patient in their choice of treatment. So with regard to the CMA, we have differing opinions, and I would prefer to retain a medical market, at least for 5 years' time, as the task force recommends. Retain the medical marijuana program, and in the end, over time, determine if it's really necessary to maintain both streams. Thank you. Thank you to you.
Thank you, Chair. I have 3 questions, if I can get them all in. Good. If not, on the second round, please. My first 2 questions are for the Minister, and the first one is about restricting access. The legislation before us provides for harsh penalties for criminalization of up to 14 years for providing young people with cannabis. We heard in witness testimony about social sharing, of sharing between a young adult and a minor. What did you hear in your consultations about social sharing, and do you think this penalty is appropriate for social sharing, and how do you distinguish it from the criminal elements of sharing?
Okay, first of all, social sharing is legal. It will be legal in under this legislation. And that's the reality that we have in relation to alcohol and other things. Somebody will, it's a legal substance, somebody buys a bottle of wine and brings it to my house, or I give someone a bottle of wine. I buy 30 grams of cannabis, somebody comes over for dinner on Friday night, I share. That's social sharing. And in fact, that is not subject to the criminal law. But what you cannot do is sell for profit, right? If I go to the retailer and buy 30 grams and then sell it to Mark to make a profit, that's trafficking. Right? Okay. Now, am I going to be charged? Maybe, but am I going to be sentenced by any court to 14 years? No, unless I am probably part of a criminal organization who on a regular basis is earning my living from trafficking in that product. And yes, for traffickers who are, in my opinion, I'm not even going to describe to you how I view traffickers, whether they're trafficking drugs or anything, human beings or anything else. They are in one business, and that is to deal with abuse the vulnerable, and others for a profit motive. And yes, they could be subject up to 14 years under this legislation. As you can tell, that would be the maximum. That would be someone who was part of a criminal organization that had been trafficking and exploiting not only the purchaser, but mules and other things for a very long period of time. Most Crown prosecutors will not ask for 14 years. But social sharing is legal. That is legal. It is trafficking that could carry up to 14 years.
Okay, thank you. I find that interesting. It's not what we had heard as an interpretation, but that's useful.
No.
Let me ask you.
We heard a lot about social sharing, right, Mark? And it's like social sharing of wine or whatever. As long as you're not doing it for a profit motive of reselling it, it's part of civil society as long as you're social sharing a legal substance, which my 30 grams will be after this legislation is proclaimed in force.
Okay. Let me stay with restricting access to young people. The legislation before us proposes that young people who carry more than 5 grams will be criminalized. Young people who...
Not criminalized. Not under 18. No, the criminal law will not apply to people under the age of 18 if they have 5 grams, in and around 5 grams.
Over 5.
Oh, sorry,
I'm saying
over
5 grams. Yeah. What do you think about this 5-gram limit? Is it too low, too high, or just right?
Mark probably has views on this as a physician. I think we talked to a lot of experts about the gram limits. Now, we did not talk specifically about the 5 grams. We talked about 30 grams and whether that was enough and what that meant and so on. 5 grams, depending on how it is used, would be more than sufficient. But I don't even want to talk about the under 18 person using, because that is against the law. But because you didn't want to we know young people under 18, some of them will use, we don't want them criminalized and potentially having long-term effects on their life. The government chose this 5 gram. It is sufficient for any young person under the age of 18 to be using.
Okay.
Mark, do you want to add to that?
No,
Nope,
I haven't.
sorry.
Oh.
Sorry. I'll put you down for the second round. Senator Housakis.
Thank you, Chair. I've had a lot of concern regarding this legislation, and after what I've heard from the testimony so far this afternoon, I have even more concern, quite frankly. In regards to your point, Ms. McLellan, that traffickers are people that we don't encourage and we certainly have no time for. We share that view. But if we go back to Prohibition, when Prohibition ended, the people that were the happiest were the bootleggers. They're the ones that had the big bonanza that came out of it. They went from being illegal to legal. And most of these traffickers right now are prepared themselves very well for the inevitable passing of this bill and are quite prepared to go from illegal to legal. But that's a whole other story. The concern I have, and it was addressed partly by my colleague Senator Petitclerc and Senator Bernard, that is the minimum age use of 18. And it's a huge concern, regardless of if it's legal or not legal, because despite the testimony today by Dr. Ware, if you listen to the Canadian Medical Association, if you listen to the Association of Nurses across this country, if you listen to the Association of Pediatricians across this country, if you listen to the administrators of post-secondary and secondary education in my province, and I've met most of them, they've written to me, I've read their studies and their reports on it. Not a single one of these people that deal with teenage kids and people between the age of 18 and 21, CGIPs in Quebec, think this is a good idea. So I find it incredible that at bare minimum we don't recognize that every person in the medical field, and let's stop mixing medical use of marijuana with recreational use of marijuana, because a number of the questions and testimony today was addressed to medicinal use of marijuana, which has been legal in this country for a very, very long time. Recreational use on the part of teenagers up till the age of 24, it is undoubtedly recognized by every medical expert in this country have a harmful effect on their mental development. So I find it very difficult to accept as a parliamentarian that I will encourage that age group to use marijuana, knowing full well this is completely at their detriment. And with all due respect, if a police officer stops my 17-year-old at a park with a joint, I don't find it acceptable for that police officer to say, put it in your drawer and you can smoke it when you turn 18. It's harmful for him at 17, it's harmful for him at 18, it's harmful for him at 20. I think the government and we as legislators should do the reasonable thing at bare minimum. And I understand all the other objectives of this piece of legislation if we can go back and forth, but I can't understand for the life of me why we think 18 is an appropriate age to start. And to compare it to tobacco or alcohol or somebody signing up to fight for the country in the military, no, this is a psychotropic narcotic.
Tobacco.
No, they're not psychotropic medications. No, they're not.
Oh.
And doctors and doctors and doctors that have come before this Parliament to address the various committees have said this. Of course, minor exceptions are the case.
Can we hear the answer, please?
Yeah, well, I'm not sure I really heard a question. It was quite a powerful
The question is
statement.
regarding the age group of 18.
So why it should be allowed at 18? Well, there were a couple of things. One thing is setting an age at 18 does not encourage people over 18 to use cannabis. That is not the purpose, and
Doesn't
certainly in
discourage.
no language. No, but it sets an age at which an informed individual can make a decision to do something which is entirely in their right to do so. We're also concerned about the statements that you made about the detrimental effects. Yes, there are young people who will be affected by the early use of cannabis, especially those that are 12 to 15 years old. It is quite clear that the risks to the brain are much higher the younger you are. Those risks start to drop as you get older, and there's a certain point at which the risks start to become less and less significant. Whether you choose 18, 19, 21, or 25, you're already on the downslope of that risk curve. The maximum risk is at that very sensitive age of 12 to 16, and that is well protected within this legislation.
So why not lift
So it's a balance.
Why not lift the limit
because
to
as
24?
Dr. McLellan, as Dr.
You can
McLellan,
call me
I've
doctor.
promoted you to a doctor, because Ms. McLellan has pointed out that there's a competing priority, which is avoiding the criminal prosecution of people who use cannabis at that age.
which is the largest use cohort, and we know they will use anyway. They will be subject to the criminal law, their lives dealt with in a series of unfortunate ways. They will continue to purchase product that is cut with gosh knows what. They will feed the black market, and when you balance, and this isn't, if we lived in a perfect world, that, I mean, it's, I guess we would all strive for that, but that's not the reality. So you have to balance, as legislators, you have to balance competing public policy objectives and come to a conclusion as to where the balance is best struck to achieve the public policy objectives that you decide are paramount. And that's what we did in this report. But to Mark's point, nobody is encouraging use. Look, if you ask me personally, I would prefer nobody ever used, right? I would prefer probably that nobody drank or smoked tobacco. But that is not the world in which we live. And therefore, how do we fairly deal with this particular substance in light of the social, economic, and criminal realities that we face as a country?
Okay, thank you. Senator Patterson.
That was not 5 minutes, Chair.
Oh, it was more than 5 minutes, my long shot.
Your
preamble took up more than half the time. Senator Patterson.
Thank you, Mr. Chair. I'd like to pursue the Aboriginal consultations that Senator Munson mentioned. And you said they were an important voice to be heard. There were articulate groups, First Nation groups, talking about Aboriginal involvement and revenues. But we heard the First Nation Tax Commission at our Aboriginal Peoples Committee say First Nations are governments like provinces and territories. They will deal with the impacts of mental health and educational and recreational needs. They are being courted to establish production facilities on reserves, and as you said, they need involvement and revenues, yet they're left out of the excise tax regime that provinces and territories in Canada have divided those up. So given your concern and your comments, what do you think about the scheme recommended by the Aboriginal Peoples Committee that 20% of production licenses be allocated to First Nation governments and that First Nations be given a share of the excise tax revenue?
As a task force, we did not make specific recommendations. What we heard was that this was both a potential economic opportunity for Indigenous communities and also a potential risk in terms of addiction and other kinds of issues for young people. That's why we said to the Government of Canada, and quite honestly other governments, what you need to do is consult more broadly with Aboriginal Canadians and through tax authorities like the Aboriginal Tax Commission, and figure out what actually makes sense, taking into account the diversity of Aboriginal voices that we heard. Nobody should think that the Aboriginal community speaks with one voice. They don't. They are as diverse as any other community in this great country. And that's why when we heard that diversity of voices, that we said to we recommend, it's clear in our report, that the Government of Canada and provincial governments, quite honestly, need to do further consultation with Aboriginal communities to determine actually what involvement they will have, whether the tax commission, the Aboriginal Tax Commission, will be involved. Those things, quite honestly, Senator, were above our pay grade as members of the task force. But what we did identify was that these were key issues of opportunity and a possibly risk for Aboriginal communities, and governments at all levels needed to take those on board.
But the First Nations Tax Commission said the horse will be out at the barn if the legislation is passed without these issues being addressed. And Manny Jules said you're going to have the same issue with tobacco as we have with tobacco on reserves, illegal operations, foregone tax revenues. Wouldn't you agree that if we are to respectfully engage with Indigenous governments, we should take the time before proclaiming this legislation that the Aboriginal Committee recommended to do those proper consultations rather than present them with a fait accompli when we're doing consultations?
No, I wouldn't, because I don't think you're presenting them with a fait accompli. What I would say is that the legislation, legalization and regulation moves forward on whatever appropriate time frame is determined. But that those discussions continue, just as they will continue with the Department of Indigenous Affairs and the economic programs they have in place to work with Indigenous communities in terms of joint venture opportunities and other opportunities. To my colleague Mark Ware's point, this is not a point in time. This is a process. This is something we will be working on together for years, and that therefore the work must, I agree with you in this, the work must be done, it must continue, but it all will not and does not need to be done finally before proclamation.
No, thank you.
Very quickly, 30 seconds.
You have engaged with Inuit Tapiriit Kanatami, and according to your consultations.
They were invited to submit.
The President told our committee that consultation with ITK, which is basically a national lobbying organization, is not consultation with Inuit. Did you get any other input from Inuit as required under their land claim agreements in the regions?
I do not remember specifically. Do you, Mark? I remember the submissions from some of the Inuit organizations. I would have to actually, if you look at the appendices, I'm not going to take time now, you will see everyone from whom we heard, except for individuals from all over the country. And we did have a small number of individuals from Nunavut, for example, who did submit, but a very small number of individuals.
Thank you.
Okay, thank you. Before I go to round two, I'll insert the chair's opportunity to ask a question here. I'll time myself at 5 minutes, of course. Last week we had three law associations, the Canadian Bar Association, the Canadian Criminal Lawyers Association, and Bar de Quebec. And the testimony from them indicated some concern about too much criminalization still in this whole process as it comes out in C-45. A couple of my colleagues have mentioned social sharing, for example. There's also this question of being close in age. You know, an 18-year-old gives to a 17-year-old. The 18-year-old could be subject to criminalization. Still a young person. We don't want to criminalize our young people, as what we were hearing from them. And young people are not just the ones under the age, but they're the ones over the age, in their 20s as well. We also hear that a person with a young person, say a 15-year-old with 15 grams instead of the 5, could be subject to criminal prosecution under the Youth Criminal Act. We also hear that while, we heard from them that while this 14-year sentence may not be handed out in many cases, if somebody is charged under it, even if they're only given a small, much smaller sentence, this could affect them in another way if they happen to be a landed immigrant, a refugee. If they happen to not have citizenship status, they could be, in fact, removed from the country, which is an additional penalty, a horrendous penalty, to be deported from the country. Not for getting 14 years, but just being charged under the same criminal act provision. So I wonder, you know, and when we talk about trafficking as well, okay, those are one set of issues, but in trafficking as well, I think we all agree that we want to get the big criminal organizations. We want to throw the book at them. But there are some smaller players in all of this who, for one reason or another, poverty, whatever, get involved in these things, get corralled into these things, and perhaps don't deserve to have a very major criminal record. Certainly if you start to make comparisons to alcohol and tobacco about these kind of things, the penalties aren't nearly as severe. So what do you think of that situation?
Keep in mind, first of all, we did not recommend in our task force report what the various sentences, maximums might be. But having said that, I think what the government wanted to do was send a message to illegal criminal organizations that if you are trafficking in cannabis, especially to young people, taking advantage of the youngest, the poorest, the vulnerable of whatever kind, there is potential for you not only to be charged, but to have a criminal record and get significant time. But that significant time, Senator, is actually, as I said earlier, it is, can I guarantee that it will only be attached to those who are members of well-known criminal organizations that every cop knows in this country and knows exactly what they're doing and the misery they're bringing to people in their communities? No, I can't guarantee you that. But those are the kinds, but that's true of our justice system now. That's why, you know, I realize, as I've said to Senator Bernard, that it is not a perfect system. But what you've identified are issues for our system right now. And in fact, you have to count on prosecutorial common sense and discretion, on law enforcement, as we do now in relation to these matters, which is why you see the number of charges for possession for personal use of small amounts going down, 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 because the police have said to themselves that, you know what, this isn't worth our time. We have got bigger issues to deal with. Yeah. So that I know, I used to...
Shouldn't we just put more into fines, fines or community service or education, restorative justice kind of measures for young people?
Yes.
That get caught in a minor. We want to get the big fish, but maybe
I
not
agree.
the little ones.
And you have to, I guess, and I understand probably it's asking a lot for some people in this country, and I get that you have to have faith that your system of criminal justice works for most people in the way it should. But to your point around diversion out of the criminal justice system, in fact, that's exactly what the Youth Criminal Justice Act does. I enacted that legislation. You and I were part of the government that brought in the new Youth Criminal Justice Act, where we put an emphasis on diversion out of the criminal courts for young people who were found to have minor violations of whatever law it might be. And indeed, that's what we would hope for the under 18 who was selling, who was caught selling to a 16-year-old. That in fact, that person is not dealt with in the court system in most cases, but in fact is dealt with under the Youth Criminal Justice Act and is dealt with in a way that makes more sense for him, her, their family, and so on. But am I asking you to believe that the system generally, not always, acts in a common sense, reasonable, proportionate way? Yes, I am.